A very warm welcome and a very good morning to everyone. Wish you a very happy Sunday. Today, I welcome you once again for this humble free legal literacy initiative. This is Vestralex free online community classes on law. Uh, we are uh, we are basically an idea, a concept, trying to understand this vast field, this vast universe, this entity of law, what exactly it means, what are the various facets, how exactly is it placed, and what is best, suited for ourselves and for the society for which law exists. So, in this humble pursuit of learning, today we have with us contributing and making it possible Dr. Ila Deshpande. She is a Center Coordinator, Center for Shaastric Studies and Research in Law, CSSRL, at Maharashtra National Law University, Nagpur. Dr. Sudame is the Research Center Coordinator of Center for Shaastric Studies and Research in Law. She is the Project Associate of Indian Knowledge Systems, IKS Research Project awarded to CSSRL, MNLU-Nagpur by the IKS Division of AICTE, Ministry of Education, Government of India. She has achieved her PhD in Perceptual Witness Misidentification, an inquiry into the legal epistemics based on Shaastric and forensic parameters at the Maharashtra National Law University, Nagpur. Dr. Ila has deep-rooted interest in the Indic intellectual heritage and has pursued her learnings in Nyayshastra informally from her acharyas. She has been a member of the Board of Studies on Indian Jurisprudence in Kavi Kulaguru Kalidasa Sanskrit University, Ramtek. She has delivered guest lectures on varied topics of this domain in multiple premier institutions. She has pursued her learnings and presented multiple research papers on topics like Tantra Yukti, Indic science of research and scientific writing, Indic remodeling of contemporary ideas on human rights, commitments with the theory of Purusharth, evidentiary and epistemic crisis in forensic identification and solutions from Nyayashastra, etc. Dr. Ila's areas of interest include forensic science. She holds a certificate in the FIS Online Peace Investigative Interviewing Solutions by Forensic Interviewing Solutions, Washington, D.C., USA. Other published papers is on higher judicial appointments and related constitutional virtues. So, ma'am, it's a wonderful opportunity, and we're deeply grateful to you for sparing time to share with us insights on this very unique topic. And we look forward to hearing your views and briefly being introduced to what exactly is Nyayashastra. Thank you so much.
Thank you, Keshav. So Keshav has instructed me on 45 minutes of my speaking time in this session. And Keshav has, also been very kind with me that he's allowed me to do some screen sharing here. So I have developed a few slides for this session. Can I start sharing my screen, Keshav?
Absolutely, ma'am. I'll just see whether permissions are...
I have, it is showing me a green.
Wonderful, wonderful.
Yes, so is it visible to everyone?
Yes.
So for the purposes of today's, just a second, I'll just take a minute to, maneuver through this. Yeah. So for the purposes of today's session, the topic that we have chosen, Keshav and I, we mutually discussed, and we came to modern applications of Nyayashastra for legal professionals. So because this topic is slightly new in today's world, It feels very different to say that the topic is new, but it is. I decided to do a little overview of these applications of Nyayshastra. Each one of them can be a different topic for a completely different session. So today, these applications are being discussed as an overview in the format of an overview. When I speak of Nyaya Shastra Indic knowledge systems, I will start here today on a very basic context, which is knowledge. Knowledge is a very neutral context to all disciplines, to all students, to all legal professionals, and that is where I choose to start today. So we are all trying to, figure out this world around us. As humans, we basically engage in a lot of pursuits, intellectual pursuits. These can be in the nature of perceiving, reading, thinking, reasoning, contemplation. We discuss, we write. So all of these intellectual pursuits can actually be categorized into two very broad domains. Now, what are these broad domains? It can be acquisition of knowledge and it can be communication of knowledge. So these can be looked at as two basic intellectual pursuits of human life. Now, when we come into the legal parlance, these intellectual pursuits start assuming a greater significance because it starts involving more complex processes and more significant processes like illegal education and something like judicial inquiries into truth, which is going to impact justice administration. So there are diverse formats of this acquisition and communication of knowledge that we come across in the field of law, be it legal education, justice administration, or law. So these diverse formats can be, professors delivering their content in classes. They can be students receiving and processing that knowledge. They can be research papers being developed on gaps of knowledge, dissemination of knowledge in varied formats like seminars, etc. Receiving testimony of witness is also a form of acquisition of knowledge and also communication of knowledge from the witnesses end. Then appreciation of evidence is where we are, again deciphering the facts. Pleadings and arguments by counsels is communication of knowledge. And then judgments by judges and also laws made by legislature. We are acquiring our knowledge and communicating our knowledge through these varied formats in the field of law. So, what is the rationale of today's topic? Today's topic is modern applications of Nyaya Shastra for legal professionals. So what is the rationale of this topic? What we are doing here is we have a system which is already functioning. So we are diagnosing some problems, some contemporary problems, and we are focusing on a study of modern application of a time-tested knowledge system. And we are also creating a dashboard kind of a thing here where we are connecting law to its allied disciplines through an interdisciplinary study. And this study, this particular session, it also has a potential. There are many respectable people viewing this here today. This has a potential to revive IKS by practically applying it to contemporary problems of modern law. And we can find solutions to curtail miscarriage of justice. And this is basically aimed at enhancing the objectivity in the entire process through scientific methods. So today's session, the whole rationale is being examined here. As legal researchers, we tend to examine that. So I have put that up also. So knowledge of facts keeping and guardianship of facts is a concern in Nyaya Vyavastha. Everything starts from facts. So it is a complex process. Understanding facts for judicial inquiries and legal education, it's a complex process. What happens is we many a times fail to appreciate what is the structure and what can be the classification of this knowledge that we are required to handle in our regular course. So this actually it is a very serious and crucial province. And as opposed to being a casual exchange of knowledge, this is much more serious. And why? Because it directly affects educating advocates and judges, administration of justice. So this has very severe consequences when it comes to the field of law. Understanding facts, understanding knowledge has very severe consequences when it comes to the field of law. So have we really reflected upon the methods that we have for this today? So there are some questions that I get posed with here. These strike me every now and then, that post-colonization, what are the methods that we have been adopting thus far to address these things? So what methods have existed? It has been an Anglo-Saxon jurisprudence post-colonization with us. There are Western methods that are prevailing, and established evidentiary methods under the Indian Evidence Act 1872 are available with us for proving or disproving knowledge in the form of facts. And engagement with each other in the form of dialectics, be it argumentation or legal research and writing, is a handed down method to us. So are we happy with these methods of appreciation of knowledge in form of facts? So yes, because this system has certainly yielded some results. So yes, we are happy with this system. But the miscarriage of justice still prevails. Now there is empirical research that can be quoted here, but I don't want to go into the details because the topic is different. But miscarriage of justice prevails, and that is why we need to also ponder some parallels. Are there some parallels to these methods that we now need to experiment? So is law as an independent discipline sufficient to handle these concerns of knowledge of facts? So the answer to this question is no. Law has to reach out to other disciplines. So law has to reach out to disciplines like psychology. It has to reach out to disciplines like linguistics, physical sciences, epistemology, etc. Okay, so it needs a more transdisciplinary and interdisciplinary and a multidisciplinary exercise for justice administration, be it for legal education, for justice administration, a multidisciplinary assistance is required for the field of law, because law by itself is not sufficient. It has to reach out. Now, what do? We have to reach out to so many disciplines. So is it not convenient if some system of knowledge is giving us a one-stop solution? So the Indic scholars, our ancestors, they have always believed in this akhanda vidya. They looked at anything in a very holistic perspective. So they did not have this era of super specialization of psychology, of linguistics, of epistemology, of ontology. They did not do all of it. They looked at one thing, they developed a Shastra looking at it, and they have the Shastra actually contains, Shastra is a science, and any Shastra, any system of thought in Indic knowledge systems will address all of these things. So Nyayshastra, if you speak of it, it is going to address your epistemology, it is going to address your ontology, it is going to address your linguistics and all of it. So which is why, why not approach such a system of knowledge where you don't have to, waver a lot. Instead, Indic knowledge systems will give us a one-stop solution, is what my research, my very humble research has revealed to me thus far. So what are the broad contours of these Indic knowledge systems? Indic knowledge systems is broadly divided into, systems that accept the Vedic authority, systems that reject the Vedic authorities. Now, we need not go into the details of all of this. We just need to understand that there are certain systems based on independent grounds that also accept Vedic authorities, and Nyaya happens to be one of the schools of thought out of so many systems of thought in Indic knowledge systems. So let's try to we have now thus far, post-colonization, during colonization, we have found our solutions through Anglo-Saxon jurisprudence, Western methods. Let's try to find some solutions to the parallels also. We never know if we find a better one. As researchers, we keep on exploring. So at least for that purpose, let's visit our own indigenous intellectual heritage. Okay, so for this session, some solutions that I could develop through my research, it has been a very humble research thus far, for some contemporary problems through modern applications of Nyayashastra. In this session, I'll be discussing 3 applications here. The first is going to be for acquisition of knowledge. I'll be discussing how Praman theory of Nyayashastra happens to be relevant for appreciation of evidence for knowledge of your facts. For the second application that I'll discuss today is communication of knowledge, for which I'll be taking up a very important aspect of the legal profession, that is dialectics, logic and argumentation, for which I'll be discussing how Vadkatha of Nyayashastra can really help us. And there is a third application that I'll be discussing that is not really out of Nyayashastra, but it is out of an Indic knowledge system. It is for legal research and writing, So Tantra Yukti happens to be a science which speaks for the content, structure, and language for legal research and writing. It speaks of content, structure, and language for any scientific work. I have attempted to contextualize this for legal research and writing also. So coming to the first one, the modern application for acquisition of knowledge, which is Praman theory of Nyayshastra for knowledge of facts and appreciation of evidence. Now, for an example, I am going to take up when we appreciate evidence. Eyewitness evidence happens to be a very significant for a part of your case. So, what are the indic methods of inquiry? Now, indic scholars have always looked at knowing as a science. We are knowing through someone. We are knowing through this witness. So, they have looked at this witness and they have examined the linguistics of it. They have examined the ontology of it and the epistemology of it. Knowing itself is considered as a science. So what they do is a knower, they institute a model of inquiry. For a Shastra Drishti, they institute a model for inquiry. If we contextualize this for judicial inquiries also, how we realize it, this application can help us understand that there is a knower who's known as a pramata. Then there is no, everybody need not get into the hyper technical terminologies of Sanskrit. Basic English here is also sufficient for you to gain basic knowledge. So there is a knower, there is an object of knowledge, there is a method of knowing, which is praman, and then there is a mode of inquiry, which is known as pramakaranam. All right. So for the purpose of contextualizing this for judicial inquiries, let's say our knower is the ordinary witness. Okay. The object of knowledge is our facts. The method of knowing is perception in case of an eyewitness evidence. And the mode of inquiry here is oral evidence. Okay, having contextualized this part for an example of an eyewitness evidence, now let's come to section 60, which speaks of oral evidence. There is ordinary witness, there is facts, perception, and oral evidence. With these form some important concepts under section 60 of the Indian Evidence Act. Okay, so ordinary witness has been defined in the interpretation clause, fact has been defined, then oral evidence has been defined. However, do we find a definition of perception in our Indian Evidence Act? So what is the necessity for instituting a definition, or what is the necessity for adopting a definition for these concepts that are not defined? For example, perception. So what happens is epistemology is a branch of knowledge which is actually a science of knowledge. So this is going to discuss the validity and invalidity of knowledge. That is the complete content of epistemology. It is said that a fingerprint doesn't lie. These are the words of E.T.L. Dorr, forensic scientist. A fingerprint doesn't lie, but a fingerprint doesn't speak. So it does need a human element, and the human element needs to avoid cognitive bias. And this can be achieved only by inculcating some epistemic discipline in us, which is why definition for concepts like perceptions happens to be important. Now, how do we now, law is not sufficient by itself to define perception. We've seen that there is no definition in the Indian Evidence Act. So when it comes to why do we have to reach out to other disciplines, why law needs to reach out to other disciplines, and why Nyayshastra? Why Nyayshastra out of all of these? So Nyayshastra has an edge over other Indic knowledge systems. See, there are many Indic knowledge systems. Sankhya Yoga happens to be there. Mimamsa happens to be there. I am speaking of Nyayashastra here because Nyayashastra has an edge over other Indic knowledge systems based upon my humble research, because it is based on ordinary experiences as opposed to extraordinary experiences of humans. And it is easy for appealing to the rational faculties of humans. The theories, methods, and their applications may be verifiable and implementable in courts. So if you discuss a theory of Nyaya in courts, it will very well appeal to the rational faculties of a layperson also and an expert also. These are those kinds of methods. So, and also there's another important facet that Navya Nyaya is believed to have taken the optimum advantage of Sanskrit as a language. knowledge. So which is why we resort to Nyayshastra for this purpose. Now, when we speak of Praman Shastra for exploring solutions for how do we understand our facts, how do we appreciate our evidence. So there are some contours of Praman Shastra that we need to see what Nyaya theory of knowledge is offering us here, and what we can explore to find our some very important definitions for. So Nyaya theory of knowledge says that knowledge can be divided into two parts. So knowledge can be based on your experiences and knowledge can be based out of your memories. Both of these knowledge can be either valid or invalid. So experience based knowledge can also be valid or invalid, and memory based knowledge can also be valid or invalid. When it comes to experience based knowledge, the valid forms of knowledge are perception, inference, comparison, and verbal testimony. So, what are the invalid forms of knowledge when it comes to experience based knowledge? Doubt is an invalid form of knowledge. Nyaya theory of knowledge tells us. Then, error is an invalid source of knowledge. Hypothetical assumptions are also considered to be invalid sources of knowledge according to Nyaya theory. So, contextualizing Nyaya theory of knowledge for the purposes of judicial inquiries, research has revealed that on the basis of valid experiences of knowledge, that is pratyaksham, anumanam, upamanam shabdah, that is perception, inference, comparison, and verbal testimony. Perception can be understood to be, now Nyaya theory of knowledge has given us definition. It is perception is something that is produced by contact between sense organ and an object. All right. So this can be contextualized for our legal purposes under Section 60 of the Indian Evidence Act, which says oral evidence must be direct. So if at all we feel we need a definition of perception, we can certainly rely upon Nyaya theory of knowledge's definition. Then inference, how does inference, how do we rely on Anuman Praman for, contextualizing our legal concepts? So if we look at circumstantial evidence, it is nothing but drawing inferences, right? So where there are two or more pieces of facts that are reasonably connected with each other, we are inferring something. So there is a science of inferring in itself, which is offered by Nyayashastra. Then there is comparison, which is identified as a valid form of knowledge. So if we speak of Section 73 of Indian Evidence Act, we are comparing signatures, seals, writings. We can very well apply the principles here. Then Shabda Praman of all, we can apply the parameters of appreciating Shabda Praman. There are two sutras I very strongly feel about this. There are two sutras of Nyayashastra which I feel completely sum up our law of witnesses. Aptavakyam Shabdah, they say. That assertions of reliable persons are a reliable testimony. And what is reliability? Aptastu yathartha vakta, they say. So a person who speaks of things as they are is a Yathartha Vakta or a reliable person. So your concepts are under Section 60, under Section 45 of expert witness, under 118 of who may testify, what can be the credibility, all can be sorted out if we examine the parameters of Shabda Praman from Nyayashastra. Then doubt, samshaya as a concept for reasonable doubt, for the concept of benefit of doubt can be explored. Then errors, when facts show that knowledge is inconsistent, there is problems of veracity and credibility, the parameters of errors and viparya can be explored for that. Hypothetical assumptions or tarkaha are also being dealt with by Nyayashastra. So applied Praman Shastra. Now I have very strongly asserted this on varied platforms that we need to start looking at our Shastras in the form of applied forms. So let's stop talking about them as some book of history. Let's start discussing them as applied sciences for today's problems, for contemporary problems. So what are the prospects of exploring Praman Shastra? It is a very pertinent branch into an inquiry of legal epistemics, right? So it is literature. What is Praman Shastra? What is Nyaya Shastra? If you look at it from a lay point of view, you can say that it is literature which is contained in Sanskrit and requires interpretation and contextualization. Absolutely correct. It has been developed over intensive debates and over centuries. Therefore, this knowledge is absolutely time-tested. It is more comprehensive owing to the practice of Akhanda Vidya. and therefore reliable, and therefore it is preferable for the purposes of law also. Now coming to the second application that I would like to discuss here today, which is on communication of knowledge. So here I will discuss Vad Katha of Nyayshastra for dialectics, logic and argumentation. So we all understand that argumentation takes a very important place in the field of law. Legal practitioners will appreciate this, that argumentation is a significant aspect of the discipline of law, along with many other professions also. But in the field of law, it assumes a very crucial character. However, study of argumentation happens to be a relatively lesser explored area. So we don't have a lot of courses being offered on how to argue. We don't have a lot of, study related to how to advance your argument, how to develop your arguments, how to advance your. It's all a matter of practice that we are relying upon. However, the aspects that are involved in this subject are as crucial as structuring, logically structuring your arguments, maneuvering through checkpoints. There can be a points of defeat in your argument. So maneuvering through all of those, then organizing your factual knowledge, systematizing your presentation, all of these aspects are involved in the process of argumentation. So we need to really develop a science for argumentation also. So how can we do it? Indic principles flowing out of Nyayashastra. Now there is a Vad Katha in Nyayashastra, which Nyayashastra has elaborately spoken of dialectics through Vad Katha, and it has come up with various parameters for, which can help you develop your arguments, be it fallacies of reasoning, be it points of defeat. You have all of it available, and you can start borrowing it for your argumentation. So Bharat, which really has a rich history of indigenous heritage through Indic knowledge systems, has evolved through consistent engagement in the exercise of verbal discussions, right? So these are known as katha. A discussion is known as katha. Katha can assume three formats. There are three ways in which you can discuss something, right? So a discussion, and now these three methods are actually based on the purpose. The division is based on the purpose for which these discussions are carried out. Okay, so there is vada, the purpose of which is knowing the truest essence of a subject or arriving at a truth. It is a peaceful method of argumentation aimed at arriving at the truth. Then we have Jalpaha. What is Jalpaha? It is the purpose of which is achieving victory. Now, this is something which we regularly witness in courts. It is a slightly warring argument, however, highly structured, but a warring argument. The purpose may or may not be arriving at the truth, but it is always for achieving victory. And third form of argumentation is Vitanda. So the purpose of which is to negate the opposing party. You may or may not have a point of your own, but you just want to negate the other party. Now, these are warring arguments which are supposed to be avoided. Sometimes we see them happening also. So these are the three forms of katha. These are the three forms of argumentation that our science has culled out for us. And now, hostile or warring arguments, as discussed, can be in the form of wrangling, which we just discussed. I just discussed jalpaha, cavil, and quibbling. So wrangling is endeavors to establish a premise. You're wrangling, you're fighting in a court, but you are endeavoring to establish a premise, although for your own victory, but it is a highly structured argument. It is based on sound principles. Cavilling does not endeavor to establish a premise. It is mere attacks on opponents. It is disagreements without any rationality, any element of rationality. Quibbling is opposing the other by assuming alternate meanings of any word or any concept. So there can be quibble in the respect of words. You can take a word to be meaning something else as is intended by your opponent. That is quibbling. So these are the form of hostile or warring arguments that Nyayashastra also discusses that we should be steering clear of. Peaceful or honest arguments, on the other hand, which is Vadaha, has been defined correctly in Nyaya. So what is that? Vadaha is that which is proposed by the aid of any means of right knowledge. So sources of knowledge are correct in Vadaha. So it is opposed from either side by confutation. It does not deviate from established tenets. It is adopted and analyzed in the form of 5-member syllogism. So it has to be a highly structured logical argument. We say Panchavaya, 5-member syllogism. Nyayashastra has offered a Panchavaya for us that, develop your argument in these 5 stages of Panchavya, 5 member syllogism, which I'll discuss eventually. And that makes much more sense when it comes to presentation also, logic included. So, and there is adoption of one of the either sides. This is the definition of Vada given to us by Nyayshastra. So the Vada Vidhi for Indian logic and argumentation flowing from Nyayashastra, if explored for the purposes of argumentation and logic in our argumentation, we are going to benefit immensely out of it. Why? Because Panchavaya for formulation of argument. There is pratidnya, hetu, udaharanam, upanay, nigamanam. So which says that these are the five. We know the Aristotelian syllogism, the 3-member syllogism. This is a 5-member syllogism, which is much more structured. It also gives us vad vidhi for argumentation. So it gives importance to purva pakshaha, which is your opponent's view, the view that you're required to refute. You are required to understand that view correctly in the first place. It gives us parameters for refuting that view, that is khandanam. We should understand those parameters coming out of the concept of khandanam. What grounds can your refutations actually meritoriously be based upon, are given in Nyayashastra. And then how to develop your own subsequent view, that which comes subsequently. We are not supposed to start off with our own view. It says that start with your purva paksha. So a vad vidhi is also being given by Nyayashastra. Then we have hetva bhasas. Hetva bhasas are nothing but fallacies of reasoning, which happen to be a very crucial aspect in the process of argumentation. So, Nyaya Shastra has elaborately discussed Hetva bhasas. There are nigraha sthanas, or points of defeat. The points of defeat in an argumentation are a very interesting part in Nyayashastra, because there are a number of points of defeat which have been discussed. However, if we go through, even if a lay person goes through that, the person can get that how to maneuver through his or her own discussions, his or her own debates, and also in courts how to steer clear of all these checkpoints in your argumentation. And then of course Vad Maryada is discussed, where it comes to ethics of argumentation. So this is Vad Vidhi of Nyayashastra for you. Then we come to, now what I have done here is, I've just given you an example coming out of, this comes out of one of my researches. I had proposed my pratidnya for that was the legal position on admissibility of opinion witness, ordinary witnesses' opinion is incongruous in India. That was my argument in one of my works. So kindly don't go into the merits of it, just understand how a very complex argument can also be demonstrated in the form of Panchavya. So this is a pratidnya. I have given hetus for it, that is reasoning. My first reason was that a reliable lay witness is an authority of facts and of high probative value. I have given examples here. Now what you can see under the heads of opinion of an expert would lose its significance in view of a reliable and consistent ocular testimony. All of these are case laws. So if I exit this presentation, I can also point out some case laws to you on this. Second reason that I have taken here is there is criticism from the discipline of applied psychology that the rule is worse than the evil it is aimed to correct. The third hetu, now, this is a very complex argument to make. However, Panchavaya is allowing me to present it in a very presentable manner. So, third hetu is disparagement of this idea through other multiple jurisdictions. So, I have discussed the Wigmore-Wilbur approach here. I have discussed how various other jurisdictions, French, Britain, and Indian also have dealt with this, and how the argument is actually incorrect, that lay witness opinions are completely inadmissible. I have also advanced some tarkaha in additional arguments in favor of admissibility of ordinary witnesses' opinion, that court's permission is in any case required. It is non-binding. It has sufficient checkpoints in the act for cross-examination, etc. There is consideration of competence and credibility of witness. There is a three-tiered mechanism of examination of witness. So these tarkaha have been reproduced. So a very complex form of argument can also be demonstrated through these Panchavaya that Nyaya Shastra offers us. And in fact, if we adopt these methods, the argument will be much more presentable also. So that was about our communication of knowledge, the dialectics and the argumentation part of it. Now I'll come to the third part of these applications. that is legal research and writing, where I'll be exploring Tantra Yukti for you all. So Tantra Yukti is basically not a part of Nyayshastra as such. It comes from Charak Samhita, it comes from Sushruta Samhita, it also comes from Arthashastra, and Arthashastra is what I have relied upon for the purposes of this research. So Tantra Yukti gives you devices. This is a science which gives you devices for your content, structure, and language of legal research and writing. Okay, moving forward. Legal research and writing, there are some identified problems of legal research and writing in today's world. Okay, it has a problem, it's facing problems of the strength of factual matrix, translations impacting justice, legal language and for precision through legalese, sentence crafting in law, the brevity concerns that prevail, gaps between theorization and implementation. These are some identified problems through, there are various research papers on the basis of which these have been identified. Okay, so what is the potential socio-legal impact of these problems? Now, these problems are bound to affect individual in particular and also society at large. So when it comes to instrumental legal writings, which are in the form of pleadings, conveyances, etc., they are going to affect the individual. The norm creating legal writings, that are legislations, orders, judgments, conventions, treaties, those are going to impact the society. Critical legal writings in the form of dissertations, thesis, research papers, articles, etc., all of these create a very high impact on the social legal scenario of our world. So there are there are multifarious concerns when it comes to legal research and writing. The concerns of a research are, there is a research problem, there is literature review involved, there are issues to be developed, then there is conflicting or alternative findings that exist, then there is structuring and writing of the subject matter, there are word meanings involved, there are sentence connections involved. So all of these, the disciplines that actually go into examining all of these are multifarious, and these are extra legal domains, right? So there is ontology involved, there is psychology involved, there is epistemology involved, there's behavioral science, there is linguistics, there's dialectics, all of this is involved. Furthermore, now goes without saying that interdisciplinary research is a trendsetter in modern legal education, and it has also been promoted by NEP 2020. The researchers, if they are present here, law students of anyone, they can appreciate this part of it, that segregation of multifarious aspects in research in this area of super specialization falls short of giving us a holistic understanding of it. We are in an era of super specialization, so a holistic understanding still lacks. So we are looking at things like this puzzle in which the pieces are totally separated. But do we have a comprehensive research science is a question. And what also occurs is the theories, methods, practices, ethos, pathos, logos of legal research and writing have been borrowed into Indian legal education from the Occidental academic contributions. Right. So there is a resounding curiosity about the indigenous contributions. Did we at all dwell upon it? Is there an Indic history to this subject? Did our scholars address the issue of scientific thinking and writing? Are there parallel methods? So we need to really ponder upon this, because if there are no parallel methods, then we are sticking to just one part of the knowledge system. Now, there is an Indic science of legal research and writing. In fact, we have a rich history of over 1500 years of development of a science, which provides parameters for methodical treatment of a subject and intelligible presentation of the same. Now, this can be, like I said, gathered through Panini's Ashtadhyayi, Kautilya's Arthashastra, Charak Samhita, Sushruta Samhita, etc. So, Tantra Yukti is basically a Indic science of construction and composition of scientific works. Now, Tantra is a scientific work, and Yukti means a device. Okay, so it is giving you devices. What is it giving you? It is giving you devices. There are various components of Tantra Yukti. It is giving you methodic devices that are known as Tantra Yukti. It is also telling you faults of a scientific work, which are Tantra Doshas. It is also giving you excellences of a scientific work, which is known as Tantra Gunas. Then there are some prominent functions of Tantra Yukti. Sorry. So there are some prominent functions of Tantra Yukti. One of it being Artha Yojana, which is arrangement of meanings. The other prominent function is Vakya Yojana, which is arrangement of sentences. Right? I'll just take a sip of water, Keshav, if that is okay. Just a couple of seconds.
Of course. As per your understanding, this is just one thing in the meanwhile, since I have this opportunity, this video is being live streamed to YouTube. So I understand, because I am going to go through all of these slides one by one. So please, I request everyone to not feel that this is going to be missed. So all of this can be found on YouTube. I will share the link on the group. If you're not yet part of the group, I request you to kindly become a part of the WhatsApp group. And ma'am, please, back to you.
Yes, thank you so much. So, yes, so these are the two prominent functions of Tantra Yukti, Artha Yojana and Vakya Yojana, arrangement of meanings and arrangement of sentences. Now, Tantra Yukti as a science, Indic science of research and writing, is providing us with devices for content, structure, and language of a scientific work. Okay, so there are methodic devices for content. For example, they say there has to be Purva Paksha, which enables the author to understand the view that is to be refuted. There has to be Anumatam, which is you're quoting somebody else. So it enables the author to know which is the viewpoint which is refutable and which is not refutable. So clubbing, what concepts need to be clubbed? Samuchaya is a very important yukti in legal research and writing according to Tantra Yukti, which is employed to bring things belonging to the same category or to unify those things that aren't in opposition. Now, a very this is samuchaya happens to be a very important concept, because clubbing, in one of the surveys, I very I can recollect that women were being the homemakers of our country were being clubbed with sex workers and such other people who need to be on the street, because they were clubbed under the head of those who are not earning up to that particular level. So, and then that was disparaged by Supreme Court. It came down heavily on the committee which clubbed these concepts incorrectly. So, clubbing of concepts or samuchaya, if explored through Tantra Yukti, can benefit a lot of us for our research related issues. Stating an alternative, etc. These are yuktis for your content. Then we come to methodic devices for structure. So, there has to be an adhikaranam, it says. It has to be employed to bring in clarity about the mainstay of the work. For structuring the content, you need to make a systematic arrangement of the topics. There have to be subtopics, there have to be elaboration. Then there are methodic devices for language also. These I have contextualized going by some judgments of Supreme Court also, but that's a completely different session that will be required for that maybe. So for language, they have gone into word meaning, that is padartha, context conscious meanings, then etymological meanings, which means nirvachanam. So for example, a caste derivation in caste matters many a times, it is understood through etymological meanings. So for example, the Dhangar caste was understood to be coming from etymological meaning dhenu, which means shepherds. That is how the court interpreted it. There is swasanya, that a scientific or technical term can actually be developed for the purposes of a scientific work in itself. You can come up with a new term and define it for the purposes of a scientific term. That is also allowed. Tantra Yukti says. Connecting words and sentences. Now, the other function of Tantra Yukti, which is telling you the doshas or faults of a scientific work, Ati Vistrut Tantra Dosha, which is undue elaboration, discussion beyond limit, Ati Sanshipta, too brief, Aprayojanam, not mentioning the aim, purpose, or utility of the work. Then Punaruktam, repetition. Then there are some Tantra Gunas, that Akashta Shabda, free from difficult words, Artha Bahula, work that incorporates traditional views along with those that cross the author's mind. Then Lakshanvat contains well-defined words. Now, these, if we start incorporating, if we start becoming mindful of the Tantra doshas and Tantra gunas themselves, we may start coming up with much more objective research, much more enhanced objectivity can be attained through study of Tantra Yukti. So, when we now all these concepts have been discussed here. But what is the import of all these explorations to the modern discipline of law? So it is to demonstrate that law, its theories and methods do have a rich Indic history to it, that these are the unexplored parallel systems of knowledge which are very much relevant to the field of law, that there is every possibility of rebranding of these indigenous systems by the West, and that India should be prepared to appreciate this knowledge and start applying and testing these methods in legal research, education, and justice administration. So now I've come towards the end of this presentation. However, I have a few suggestions and a way forward for how to take this knowledge forward. I have expressed these concerns on other platforms also, that let's stop calling our own Indic knowledge as ancient, because when we start calling it ancient, then we are actually reading it in history books only and limiting it to that. There's no problem in reading history. It is a wonderful subject and we should be rooted enough. But if we keep on calling it ancient, we are never going to contextualize this, and we are never going to attempt experimenting with this. So let's stop calling it ancient. Let's start calling it time tested, because it is really being tested through centuries. Now, Shastra should be contemporized. So, like Nyayshastra is being attempted to be contemporized in these humble ways by me. These Shastras should be attempted to be contemporized by other disciplines also. And specifically for the purposes of law, we need researchers who can contemporize these Shastras, because there are varied topics on which research can really happen here. And it should happen in a staged manner and in piecemeals. Very small topics should be taken at a time. Sanskrit language should not be an impediment when it comes to exploring Indic knowledge systems or Sanskrit based knowledge systems, because once you start seeking that knowledge, it is definitely going to come to you. So let's not just theorize it, but start using it practically. Sanskrit universities are there, Sanskrit scholars are there with us today who can help us, and that Shastras need to be viewed as applied sciences is my appeal to everyone here. These are sciences which are looking forward to having new Shastrakaras from our generation. And the idea of Sarve Janaha Sukhino Bhavantu can certainly be achieved through Indic knowledge systems, and if we start exploring them. So this was my humble attempt at taking these applications of Nyaya Shastra forward. And there is much more to research. There is a lot to research. I must express that this is just the tip of the iceberg, and there are very limited things that I have addressed here. There is a plethora of time tested theories right there available for all of us to explore, and we can immensely benefit. We can heighten the objectivity in our processes, and I think that is how it will certainly benefit the legal professionals, law, and legal education also to a large extent. So that was about it. I'm open to any questions if there are.
Right. So, ma'am, first of all, thank you so much. I just cannot express in words how deeply enlightening your session has been. And absolutely, there are ample number of requests for the presentation and the slides. Once again, I want to reiterate, everything is there on YouTube. I've also shared the group link with everyone so that people can stay in touch and get whatever details they want. So along with this, ma'am, there's certain questions which have come in the chat box to me personally as well as for everyone's perusal. So I'll just share.
I'll
So
just open the chat box and I'll try to
Mr.
address.
Mr. Sanvay's Sanvayji's question is that would you want to ask yourself, or should I ask on your behalf? So, ma'am,
I think
I'll
his
only ask.
question is, he's written it there. How shall we determine when and where to apply which principle? Need examples of applicabilities. Yes, when and where to apply which, see, this is a huge research. So, like I said, this knowledge is all in Sanskrit. First, it needs to be interpreted. Secondly, it needs to be contextualized, right? So, what I have presented before you all today here is based upon my research, of course, which is ratified by some senior scholars and some seniors that I have had the good fortune of working with. So it is only research which will reveal. So thus far, whatever I have presented, it has been leading Sanskrit scholars have been on board with me with these ideas. So only through research this is going to evolve, which is why I say we need a lot of researchers, and because there are so many aspects to research and Indic knowledge. Like I said, what I presented, this is just a tip of the iceberg. This was an overview, and if we have many more researchers in this field. At Maharashtra National Law University, Nagpur, we have a research center dedicated to this. I'm the center coordinator for that. I'll be willing to, collaborate with anyone who's interested in this kind of a research and take it forward. So how and where to apply which principle? Once contextualized through reliable research, that can certainly be spoken of.
Does
Mr.
this
Keshavji, I just wanted to ask one thing.
Yes, sir.
Ma'am, I have seen over the last 30 years of my practice in law in various fields, Keshav knows it. But we see today in the courts, when the matter comes on arguments, even in the Supreme Court, right, the present arguments which were being addressed under section, that Article 370 issue, wherein the J&K was, I would say, finally included our Indian system. We see more of Jalpa and Vitanda, the nature of arguments being advanced nowadays, rather than Vad.
Yes, sir. Namaste, sir. Nice
Namaskar.
to be talking to you today.
Namaste,
So,
sir.
yes, sir, that is, I get to discuss this a lot with a lot of lawyers also, and with a lot of Sanskrit scholars also, that in courts, what is happening is major.
We are only trying to show the other person incorrect. So we
Right.
ourselves are standing on sand without any solid footing. So, and even the judges are taking up those arguments and discussing those arguments in the judgment. And that's the reason what I feel personally, that because
Right,
I am also, in my own humble attempt, is working on these fields for the last 1.5 years now.
So nice to know, sir.
So, like, see, there are judgments of a single judge, right up to the level of apex courts. Then there is a doubt in the judgment. Then we go to the 2 judges bench, then 3 judges bench, then 5 judges, then constitutional bench. Then that law is again changed.
Yes.
So all these judgments, if we see it, are suffering from Hitvabhas.
Yes.
Majority of these judgments which are being set aside either by the superior court or reviewed by the courts themselves.
Right,
On a particular legal point. That's why the crystallization of law in our country after independence is not clear. That today the law on a particular point is X. After 2 years, we say it's Y. Especially in the penal statute and the tax statute, it's absolutely horrible, and it's a mess. It's a mess. And so, how these judges in their judicial academies have to be told about this, that the ancient, without calling it ancient, the actual science which is there, time-tested science of law, that Nyayshastra and its collaboration with Mimamsa, rules of interpretation. Because today we study interpretation by Maxwell, whereas thousands of years ago we had our own Mimamsa rules of interpretation. So how to gel, because this lecture was slightly confined to Nyayashastra, and I'm sure because of the paucity of time, it's very difficult. It's a very vast field that we can't discuss the rules of interpretation as laid down by Purmimamsa, by Gemini and other scholars. So you think that at the teaching level, where the syllabus of law as a subject is being made,
I get your concern, sir.
Why can't we include these science, this piece of science in piecemeal manner? And second aspect,
absolutely get your concern, sir. So we have attempted this. I feel happy to share with you that at NLU Nagpur, we have actually we had offered courses to legal professionals based on Shaastric method of argumentation. So where we tried to equip them with the knowledge related to Vad Vidhi. So Purva Paksha, Khandan, Uttar Paksha, then Hetva Bhasas, Nigrah
And
Sthanas, all are being disseminated, sir. To our students also, we have proposed integrations in the mainstream of law, and to legal professionals also, we have been offering a course on Shaastric method of argumentation, sir.
I was just thinking of writing a letter to our Bar Council of India, which actually finalized the curriculum for law schools and other things. That now, when the Indian knowledge system is now being considered as a science, it's a time-tested device to reach at the right conclusions. Why can't the Bar Council and the institutions and universities take up this issue and reframe the curriculum for legal education? One
It
aspect.
is the need of the hour, sir. So
And
when we
secondly,
undertake such projects, what we always make it a point that we give out recommendations in the form of already readily designed courses. So we have courses available for appreciation of evidence based on Indic principles, course available for argumentation based on Indic principles. All of those courses we have kept available with us, sir. So anybody willing to take that up, specifically judicial training institutes, judicial officers training institutes are there in our country. Then legal education at the level of undergraduates also we are planning to
yeah.
integrate in mainstream, sir.
And one more aspect I wanted to discuss with you is that we have plenty of Latin, Greek words in our rules of interpretation in our legal books. Why can't we have Sanskrit words in that?
We have attempted that, sir. So we have tried to develop. We have a lot of Latin maxims and phrases. So
Yeah, that's why
Sanskrit.
can't we have
So
those
Nyayas out of
sutras and
Sanskrit.
sutras?
Yes,
Yes,
yes.
yeah.
That is being worked upon, sir. So a glossary or maybe the Sanskrit phrases for law. Sanskrit.
That's what I
There
was
are
thinking.
Nyayas,
I'm coming to that. I
yes.
think that you just asked that you are welcoming the persons who have some interest in that.
Yes,
We
yes.
have rule of maxims, big books on maxims, legal maxims. Why
Yes,
can't we make a book on Sanskrit suktas, having that bearing on the law and the legal interpretation and
I
writing
feel
of
happy
judgment?
to share with you, sir, that one of my students, through his research papers, has already developed some Sanskrit maxims for law. And there are some other people also working on the same domain. I'm trying to bring these people together so that we can develop something more comprehensive on this. So we are working on it.
Ma'am, I am Vinod Kumar. Keshav knows, but I would like to have your number from Mr. Keshav. And
Absolutely.
I'm going to bother you on certain issues which I have concern and on which I have been working for the last 1.5 years. And then I would like to have whatever material you have, papers you have published. I would like to have an access to those, ma'am.
Most welcome, sir.
Sir, absolutely, sir. Actually, what I understood, Vinod sir, was that, ma'am, Vinod sir, I just very humbly just want to also introduce this fact is that Vinod sir is very dedicated and committed to the cause of, first of all, obviously advocacy and young advocates, but also to the cause of what exactly is the traditional Indian knowledge system and how it can be preserved and properly presented to people. So, sir, thank you so much for your question. I hope you got your answers for the timing. We'll take other questions. Any other questions which are there right now, which anyone wants to ask? Or, ma'am, I have certain questions which I can obviously.
Yes, please, Keshav.
Yeah, so I'll just ask if anyone has any question, please feel free to jump in when you think of this. So, ma'am, the principles are done. So there is this one question, ma'am, which originates from the previous conversation itself, that in the current structure of, in the current legal structure, has any bit of Nyayashastra been inculcated? Has any bit of Indian traditional knowledge systems, has it been inculcated?
In courts?
In the current court system, in the current be it the constitution, be it any legislation, where you have seen that effectively
I have
certain
not
aspects
seen
have
this,
been.
Maybe lack of my knowledge, but in my knowledge, I have not seen this. There is this right now. This is on a research level, which all of this is happening now. Bar Council has constituted a committee on, they are trying to bring it closer to the local languages. Legal terminologies are being brought closer to local languages. So a transition vocabulary is attempted to be developed in Sanskrit. So from Sanskrit to local languages. So that is happening, I know. So when that happens, for sure, the statutes also may have to incorporate some of those words. That is a very good way to go about with it. But I would rather assert here that we need to start adopting the methods. Instead of writing something about, we need to start equipping people who are legal professionals. We need to start equipping those who are legislators through some courses on Indic knowledge systems. So wherever possible, they can start incorporating these techniques, these methods, and start relying on these theories for the purposes of be it legislations, be it governance, polity. These can be borrowed.
Ma'am, one very important thing that you highlighted in your session today was that we should stop calling it ancient and rather start calling it tested, time tested. So, in this respect, also, one humble thing that I want to ask you is that is there why is it still relevant today? Why should we rely still on such, if something we have ourselves had to call it ancient, then what is it still relevant to?
Keshav, have we asked that question to the Western methods that we have adopted? So if we have not posed that question to that system, why pose it to our own? That is one way to go about with it. Now I'll give you a very technical answer. That these are, like I said, these are sciences. Right? Only because it is said in a different language, which is Sanskrit, which calls it Shastra, doesn't make it anything different from a science. So if it is science, it is relevant in your practical life, right? We should start looking these as not just theories. Why am I saying that stop calling it ancient? Because you're reading it in history only. So if you stop calling it ancient, and why do we call now John Locke, Rousseau, Plato, Aristotle? These are also old people, right? Do we call them ancient? Do we call their theories ancient? Ancient Western knowledge systems, is it called that? Why ancient Indian knowledge systems? Why not modernize them? Why not contextualize them?
Absolutely, ma'am. Absolutely. These are questions which require very sincere deliberation. So I have a lot of questions, right? I am deeply interested in the Indian traditional knowledge system or the IKS system. So I will keep on asking till the time ma'am permits. But in the meanwhile, if someone else has any questions, because this is a very unique opportunity that we're having today. Usually we're discussing law, modern, so to say, legal things. So that way, if someone has a question, it will be really fantastic to hear. So another question, ma'am. So I'll share a brief anecdote about myself before I ask this question. So I had the opportunity of studying Sanskrit when I was small, and so everyone, let it be to your discretion how you want to judge me, but how you want to judge me for my spelling. So ma'am, in Hindi, मैं बहुत अच्छी हिंदी बोल सकता हूँ, बहुत ही बढ़िया, लाजवाब. लेकिन जब वो लिखने पर आती है तो वहां पर मुझसे कुछ गलतियां होती हैं. तो क्योंकि उसमें वो छोटी बड़ी किधर जाती है, किस टाइप की चीज है. तो मैम संस्कृत और ज्यादा टेक्निकल फॉर्म है, एंड द बिगेस्ट चैलेंज व्हिच एवरीवन सीज टुडे इज संस्कृत. I have had 2 pages, ma'am, 1 page and 1 page. 2 pages, overall spelling mistakes. I had my Malviya sir, who was a very fantastic sir who used to teach me Sanskrit then. But on 2 pages, he got 300 spelling mistakes. I genuinely, I kid you not, 300. That was the day when I realized that there are more than 300 words in 2 pages. So, but fact is that Sanskrit is such an impediment. How does one overcome that? Or is it truly an impediment? Should it be seen like that?
So, Keshav, for lay people, I would like to assert here that there are many scholars who have made it easy for us. Okay, so there are reliable commentaries which we can start from commentaries. So we can't be expected to, and I have been like you, I have no Sanskrit background, right? I started from commentaries, and many researchers like me, we start from commentaries, the commentaries and authoritative commentaries. Now, this you have to verify with some Sanskrit scholars that can we rely on these. So, normally, what we do at NLU is we have an MOU with Sanskrit universities. So, those are our experts. We take all our knowledge from there, and the authenticity is understood from there. So, once we know that these are reliable commentaries, we start from there. So these commentaries are going to equip me with the Sanskrit words, right? Any layperson cannot be expected to pick up a completely Sanskrit text and start understanding it. So start from commentaries. It will equip you with some words, some phrases, and slowly it won't be the day won't far when you will be, able to pick up a book and actually read it in Sanskrit and know it for yourself what it is talking about. That day won't be far. It should not be an impediment, because there are many people who have worked a lot in this domain. So Satish Chandra Vidyabhushana, then Satish Chandra Chatterjee. There are many such authors, Radha Vallabh Tripathi ji. They have contextualized all of this for us. We have a lot of books. So I started reading in those books only, and they familiarized me with these terminologies, and that is how it led me to the original text also. Then I started reading original text also in Sanskrit. So that is how it can happen. It's a process, but it happens. So if you are seeking that knowledge, it will certainly happen.
So, ma'am, with your permission, I also want to humbly interject and just add one more thing, some very personal thing about you, right? So I'll just mention it since we're discussing it. So, ma'am, you have had very good opportunities of learning right from the start. Your gurus, right? So first initial gurus, they are at home. Then come the the gurus that we get to acquire from the rest of the world, and all the what the universe gives us. The first gurus that the universe gives us is obviously the mother, and then the father. Your father, uh, Justice Ravi Deshpande sir, and first of all, I want to thank him for. It is due to sir that we have ma'am here with us today. First of all, literally, and also because he suggested that we were having a discussion, and then ma'am's topic came up, and then he was like, she's actually doing work on very different tangents, and then when I inquired, then I got to know that this is what is happening. On further inquiry, I got to know that ma'am has had even further guidance from Shri K.H. Deshpande sir, who was senior advocate and practiced the Supreme Court as well as various high courts, and whose grandfather of ma'am, and who has considerably under whose influence ma'am has grown up and obviously been acquainted initially with all of these thoughts. So, ma'am, and right now also you're working at NLU. You've studied there. You've done your PhD also over there. So, ma'am, what about so idea behind these classes is to be able to effectively reach out to every single person in this country, because constitution applies to everyone, चाहे किसी भाषा में लिखा हो, चाहे किसी ने बनाया हो, चाहे किसी तर्ज पे बना हो, बन गया। अब उसकी अमेंडमेंट बहुत लिमिटेड है, थोड़ी सी भी बात पे हर कोई चिल्लाना शुरू कर देता है कॉन्स्टिट्यूशन कॉन्स्टिट्यूशन। पढ़ा किसी ने भी नहीं है, कि बहुत ही कम लोग होंगे मैम जिसने कवर टू कवर पढ़ा होगा, शायद ही 10 लोग होंगे जिन्होंने लिखा भी होगा, वो भी टुकड़ों में लिखा होगा। मैं नहीं मान के चलता किसी एक आदमी ने पूरा शुरू से लेकर एंडिंग तक आगे का फुल स्टॉप लगाया होगा। तो ऐसी सिचुएशन है मैम जहां पर इतना ज्यादा अज्ञान है पूरी दुनिया के अंदर, उसके अंदर जहां पर हम इंडियन नॉलेज सिस्टम्स की बात करते हैं, वहां पर वो जो ज्ञान को हम पहली चीज एक चीज जस्टिफाई कर पाना कि नहीं हम जो बोल रहे हैं वो सही है। एब्सोल्युटली मेरे हिसाब से तो उसके अंदर बहुत मेरिट है और उसको डिबेट करना चाहिए, उसको आगे रखना चाहिए। लेकिन साइमल्टेनियसली कि कैसे मैम जो बच्चे हैं, अब कोई उड़ीसा में रह रहा है, कोई त्रिपुरा में है, कोई तमिलनाडु में है, कोई जम्मू कश्मीर में है, कोई लेह लद्दाख में है, अब उन सारे बच्चों तक मैम कैसे वो ज्ञान, अगर हम सोचें कि क्योंकि एफिकेशियसली, वरना सब्स्टिट्यूशन तो सब्स्टिट्यूशन है, अगर हमने एक पुराने किसी सिस्टम को, एग्जिस्टिंग सिस्टम को बदल के पुराना सिस्टम भी अगर लगा दिया, मैं बोलता हूँ कर दो, लेकिन उसके बाद अगर उसके अंदर वो एफिकेसी नहीं है, if it does not still trickle down to every single person, how does it efficaciously reach that knowledge? How does it efficaciously reach to everyone and not just a few privileged people? How it has been since forever. The basic, I think, challenges with.
Keshav, now the whole objective of instituting research centers like we have here at NLU is to mainstream this knowledge. Okay, like you said, even we say Antyodaya. So the last person should also benefit out of it. The last person out there should be a beneficiary of what we are doing. So this will happen if this knowledge gets mainstream. By mainstream, what we mean, undergraduate courses हो रहे हैं, तो उसमें एक एडिशनल कोर्स इंडिक नॉलेज सिस्टम करके न्याय में ये पढ़ना है क्या, ये ऑफर कर रहे हैं ये कि इलेक्टोरल में एक्स्ट्रा क्रेडिट ले लो. नो, इफ वी स्टार्ट इंटीग्रेटिंग, एविडेंस में प्रमाण पढ़ रहे हैं, अगर इंटरप्रिटेशन में ये पढ़ रहे हैं, if this is happening, if it is mainstream, then it is going to perpetuate. So from, if you're saying a younger child, it is the duty of a university, of a research center also to reach out to the society, right? So we at our research center, at least we try to develop some manuals for a child's education also. So how this knowledge can be contextualized for students also, for younger students also. So that happens through such research centers. Interested researchers, like through the platform that you have launched here, such platforms are instrumental in bringing these people together. Now through Vestralex, for example, you've got such, how many are there today? 24 participants have come out of the title of this session.
I'll tell you. Okay, now, ma'am, I'll just want to interject. We send about 5,000 invitations for every single class. The only fact is that it's free. There are about 700 people in the group, more than 700, some 700, 800 people are exclusively for the group, only notification group. How many people join? Right? And ma'am, there are justices from Honorable Supreme Court coming. I just cannot tell you the kind of people who are there. Even right now, we are just blessed. The quality of the people who are there in the classes. That is the only reason why we want to do this. But our idea is actually to be able to effectively reach out to people.
Yes. So to such platforms which bring these people who are interested together, and then through nodal authorities, there should be nodal authorities. So our research center is a nodal authorities for multiple projects that we take up. We take up in association with Sanskrit universities, with other universities, with judicial training academies, and then we perpetuate these courses in the society, right? So this you can see happening in one district, in one state. But if you want to take this down, this can also trickle down to students in school if there are manuals. Now, in fact, I'll show you right here. Somebody has done a wonderful work. I'm glad this book is right in front of me. Integrated, I can show you here. See, this is Integrated Indian Sciences, Bharatiya Vigyan Pravesh series. There is this researcher, a very small undertaking, entrepreneurship, you won't believe. They have developed a level 1 Indian Sciences book for students. So they are teaching Indic sciences in the form of Panchamahabhutas, Indriyas, Ashtanga Yoga to students in the most illustrative manner. Just look at this. I'm not promoting anything, but I'm saying there is a lot of research happening in this country. So that those people, if brought together, which happens on such platforms. So very recently, I was at IIT Roorkee. So Indic Knowledge conferences keep on happening. It is there where we come to know what all is happening across the country. The only thing is, we don't understand how many people are benefiting. There is an immense, the number is big, which is benefiting today. But yes, this has to only increase. We are living in crores, right? So this has to only increase. So that can happen through dissemination of knowledge, and dissemination only if mainstream. So if this knowledge is taught to our school students, it is mainstreamed in their textbooks, it is mainstreamed in law textbooks, it is mainstreamed in other disciplines textbooks, there is no other alternative than for them to explore these. Now, ye thopna nahi hai. All I'm saying is, look at this as a parallel system. Now, this also, if you, as a researcher, if you don't know what is your parallel knowledge system, then your research is not complete, right? So if I'm exploring only one system of knowledge, there is no alternative I'm looking at. Maybe there is something that the Western epistemology is offering me in a much more better way. Maybe there is something Indic is giving me which Western does not have. So we need to explore parallels. We should look at these things like that, and not, compartmentalize things like this is ancient, this is Indian. Why? We don't call anything of Western society as ancient or that. We just read it, right? School student being given a textbook on humanities or anything, a college student being given a textbook on sociology, the person won't doubt that knowledge. They won't doubt those authors. Aristotle को कौन doubt करेगा? Aristotle है. But हम अगर गौतम का न्यायशास्त्र पढ़ते तो हम उनको doubt करेंगे. बात वो भी नहीं है. We should just understand that we need to explore a parallel and then know for ourselves what is suiting best for the system. Take the best practices of we are living on a global level. So we have to take best practices from everywhere. So it's not like yehi karo, but I'm saying this is also there. So try to explore this. Is it giving you a more effective solution? Or is it complementing or supplementing something that we don't have today? Let's try, let's check, let's experiment. If we don't even experiment, we won't know.
Ma'am, we are absolutely with you in this noble mission that you're championing, and I hope and I pray that we get the strength. I genuinely, with all the power that can come to us, I pray that God may bless us with that kind of strength. All the people who are present over here, people like Vinod sir, people like uh, all people who have considerably given so much of their time and their life to this concept, and that we can effectively somehow contribute in your mission and
No, no,
let
not only
let
that, Keshav,
it
we are grateful to ma'am for giving such an insight of the subject.
No, sir, I'm just a very humble researcher.
No. It's you have given us a great insight. Though I told you that I've been working on this for the last about 1.5 years, along with my legal practice, and it's a vast field. The only
Yes.
thing is that we have to feel pride in that we are
Yes.
studying a knowledge system which is time tested for years, thousands of years, and
Yes.
we are, I would say, other than referring to the Western authors as a I would say, initiator of certain concepts. We have our concepts settled and time tested for thousands of years before that. So we should feel pride in that. That's what I
West has helped us immensely. West has helped us, but then why lose our own? We have, who told us to lose our own?
Yes, that's the
West has also helped us, and West is also now rebranding our own systems for us
yes,
and representing it for us. So why is that required to be done? What are
yes,
we
you are
doing?
right. You are right, ma'am.
ma'am,
Thank you very much.
all right, so I just asked because Chala sir is also here, and it's a blessing that sir has supported us very greatly. So if and ma'am sir is very keenly interested in the topic, and he's mentioned to me the value of this topic today, made me appreciate it even more. So if you so it'll be really great, sir, if I can just request you to kindly uh, share 2 words with us.
Ma'am, I am really beholden and thankful for the wonderful presentation. In
Thank
fact, it's the last 15, 20 years or 25 years I've been troubled with the very concepts and the methodology of following either maxims or Maxwell or Shroud or whatever the interpretations. Especially, I was troubled with you say donkey, this is not a donkey. And then they say it is a defined like this. So it is so. Courts also say because it is defined so and so, so and so. There is no logic. There is no reasoning. Except that blindly you have to accept because it has been defined like that. My journey with respect to questioning and also doubting with regard to these aspects in my own way, and ultimately not able to do anything because the Supreme Court says so and the High Court says so, without being any disrespect to any of my brothers and senior judges and also the judges who have attained. We have become so precedent ridden. I often jocularly call as we follow the big sheep, the sheep mentality. And maybe we have been following all these interpretational skills or the ones which you have presented today, the various way in which the actual argumentation or argument will proceed, and what are the inputs which are required to be looked into. Maybe as a practicing advocate, we may be doing some of them, but nobody has taught us, except that by observing that, okay, this is the way. You write down the facts and then thereafter this thing, and you make a presentation. And as in fact, Vinodji has just now pointed out, it is a more than Vada, it is a Vitanda. You say whatever other man says is wrong. And the judges choose one of those, this way or that way. Though Justice Markandeya Kadju in one of his judgments tried to say that why don't you follow the
Yeah, that judgment is on Mimamsa law of interpretation. He wrote it like
yes, it's only one judgment
back in 1993. It was published in SSC.
electricity matter.
Yeah.
Though he wrote more than two to three pages, but the as you rightly put it, the systematic teaching is not there. Maybe it is a time that we need to do, but we'll have to do it fast. See the pace with which it is going. After all, as I said, the multiplication of the precedents is so overwhelming. After a particular point of time, by the time you learn and you put it to practice, nobody will be really interested. Today we are in a speed age. Not even speed. It's not even a jet speed. It's a supersonic jet speed. So how do we make it? And also the lack of books. In fact, I tried to get hold of some books. I couldn't find much. So maybe a person like you quickly will have to, in fact, the presentation which you have today made, you should make it into a form of a book and then ensure that it reaches people. No, at least to create a curiosity in the young children. Oh, this is a way we need to look into. And maybe, some of us really can be of help in getting it printed and published and distributed. Unless it is done.
A very good suggestion, sir.
It will remain in your mind and it will remain in, this thing, and then Kashyap's and few of us who have heard. And then we say, all right, in Hyderabadi language, we say Talia. There ends the matter.
Further, sir, I'm just assuring you that soon you will find new articles, new chapters, new books on these things, and we'll be able to achieve the targets.
So NEP 2020 is enabling this in the best possible way, because
now they have taken it. Yes, Indian knowledge system is a part of the new education.
Now people have to. So now, though, this problem does not remain that how will people start taking this up. Now people have to take this up. So that does not remain a problem now. In what manner they take it up is a concern which universities can try to solve through our research centers. So methods can be demonstrated.
Few of the universities who have that kind of the like-mindedness, probably they can adopt, and they can also be in touch with and in the law students level. In fact, I know some of the people from, one or two people from ICFA University are present in the present webinar. Probably my friend Tarak Srinivas should speak.
Sir, namaskar, sir. Sir, namaskar. Sir, namaskar, Bahinji, namaskar. See, the only one problem for the advocate fraternity as far as the NEP is concerned, that we are kept out of NEP 2020. That was the major problem. Isn't it?
So, Tarak sir, first of all, welcome.
Namaskar.
Namaskar and welcome. And
No,
so the NEP,
we have to fight it. We have to fight with the education ministry. Why should we were kept out? And we should also be as an integral part of NEP 2020. Otherwise, whatever the benefits are there, which are supposed to be for all the students, will not be applicable, will not be made available to the law students.
The problem is, because in legal education, the curriculum is being approved by the Bar Council of India. So there, everybody is aware that what type of curriculum are being.
No. See, we should not find fault with the Bar Council. We should find fault with NEP 2020. Why? Because it was in the exempted category.
So, Sir Tarak sir, absolutely. So I understand, and I also understand the fact that I appreciate the fact that this concept of fighting. What I will suggest is that it's working together, because harmony is most important. What ma'am has also suggested
Correct.
inculcating its ideas, its thoughts. Every idea, every thought, sir, has its own time. And whatever is the most appropriate time for an idea to win, it will absolutely succeed. So obviously we have the best guidance. Salazar's guidance is there. So appropriate, whatever remedies are there, they are available in the courts of law. And absolutely justice is, I think it is something which the universe does. And human beings, judges are just vessels to whom that universe, it flows its energy. And obviously all of that will come, But sir, we'll discuss this topic of the new education policy at a different time. I understand that we obviously have
and Vaiseshika darshan is also very much important.
Absolutely.
We are talking about only Mimamsa and Nyaya, but Vaiseshika is also very much important.
Which is why I said, sir, it is just a tip of the iceberg. There are so many systems of knowledge available with us, apart from Nyayshastra also. This is just one bit of it explored, and there is so much to look into. So if we actually take a deeper dive into it, we will be boggled with what all concepts are available with us.
Correct. And not only that, there are Dharma Shastras, there are Smrutis. See, people are talking about Manusmriti. Manusmriti was not put to implementation in any yuga. We are supposed to implement only Parashara Smriti as far as Kali Yuga is concerned. So there are so many other issues, ma'am, which we will discuss in person, and then we can conduct some series of webinars through various organizations, including ICFI.
Sure, sir.
Thank you, Kodandram sir.
Thank you.
Thank you so much, sir.
Thank you, Kashyap. I'll have to leave. I'm just
absolutely, sir.
Madam, I'll be in touch with you. I'll take knowledge from you forward. More this thing.
No, sir, please. I would like to learn from you, please.
No, I'll be following.
It's a pleasure. It's a privilege to have this opportunity to learn from you and from Vinod sir and from everyone who's been participant today, and most humbly from ma'am, Ila ma'am. I cannot thank you. I cannot express my gratitude to you in words for not just giving us time, but giving us extra time also. And
so you don't have to express that gratitude.
Ma'am, that's the blessing, I think. So absolutely grateful to you. But just on the parting side of it, what I do understand from today's session is that there is a lot of more conversation that needs to be done around this topic. Simultaneously, there are very particular questions regarding what are the various, how you mentioned the argumentative skills also, how exactly. So there's a lot that can be done. And ma'am, we hope that we'll have more opportunities in the near future to keep learning and improving ourselves, and hopefully better disseminate information around the IKS.
Always there.
Thank you.
Thank you so much, ma'am, with your kind.
Thank you so much.
Permission, I hope to end this class today and hopefully see you soon for some other class.
Thank you. Thank you so much.
Thank you so much. So in the meanwhile, everyone who has joined, I thank you very deeply and very humbly for being participant to this humble initiative. It's your initiative, to be honest. Vestralex is your law. Our idea is to be able to effectively get the best minds to everyone, and we're trying to reach that through YouTube, but it's still being free है, बिल्कुल फ्री है, सब कुछ फ्री है. उसके बावजूद अगर हमें इतने challenges आ रहे हैं, तो सिर्फ इतनी request है सबसे कि if you find any merit in this initiative at all, kindly please share with your friends, with your colleagues, with your associates. Let them know, get them to join, get one person to join with you if you can. However you think best. It's like a class thing. Education should not stop. क्यों इतना बड़ा होके कोई फायदा नहीं है जीवन में? And let's be students. And all big lawyers I've seen, they only, they always call themselves as students. Judges also, they usually call themselves as students. So हम क्यों अपने आप को deprive करें? कोई कुछ नहीं रखा है इतनी जल्दी बड़ा होने में. But मेरा ज्ञान aside, if you've still been here, if you're still here, please like, share, subscribe the YouTube video. Hopefully we'll get some traction online. Also, please do comment whatever your feedbacks are, because that ways we get to be able to reach out to our faculties. They get to know what has happened They're doing it for free. Everything is pro bono. Feedback is most valuable in this initiative. So with that, I wish you a very happy Sunday. Wish you all the happiness, wealth, success, everything for you, and have a wonderful day till we meet